You each will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes. This is State versus Ammons. And so the only warnings or cautions I want to give you is we don't mention victims' names. We are being recorded, and it is also live on YouTube. So we want to make sure that the victims and any children are protected and the names are not used, that only initials or just refer to them as a victim or a child. And the appellant may have up to 5 minutes for rebuttal.
All right. Good morning, Your Honor. May it please the court, Attorney Alyssa Barbosky on behalf of Jamal Ammons. I would like to reserve 5 minutes for rebuttal, please.
Thank you.
All right. This is a case where Mr. Ammons, the boyfriend of the victim, was the only suspect looked at. He was investigated because there was a shooting. The police were called and they came and saw the victim laying on the ground, and they attended to her. Somebody pointed out that she has a boyfriend, that he was right across the street, and the police looked at him, investigated him, and then looked no further. Mr. Ammons was, the whole time that the police were there, and before then, he was kind of pacing the road, frantic. Neighbors testified that he was, screaming and hysterical, as one likely would be if their significant other was shot. And about 4 minutes later, the police arrive. And in that time, Mr. Ammons is still there. He is still across the street. Police testified that he was going to get into a white SUV, and they approached him. They said, "Hey, can you please stay? This is an ongoing crime scene and investigation." He ended up staying. He sat on the porch. Detective said it was, not too long, but neighbor said he stayed around for, at least a few minutes. And then while the officer left Mr. Ammons to go attend to the victim, he eventually got picked up by some friends in an SUV and left with them. And somebody noticed it. The police radioed for them to go get him and pull him over. He was all of 100 or 200 feet from where the crime scene was, and the officers pulled him over. The SUV wasn't, using any speeding or evasive tactics to avoid, getting pulled over. They immediately pulled over. He was in the back seat as a passenger of the SUV. And once, they were apprehended, nothing happened. He didn't try and flee. He didn't try and, resist arrest. He wasn't trying to basically do anything to evade detection from the police. He complied with their request. They handcuffed him, and they went on with their investigation. At this time, when actually he was leaving, it was stated that the officers and the life care was taking the victim, to the hospital to be treated for her wounds. And so eventually Mr. Ammons is charged with attempted murder and other various counts, and he takes it to jury trial. At the end of the jury trial, just for a little procedure for this purpose, they are given a flight instruction. The flight instruction was given over defense's objection, and he is consequently found guilty after the trial of every count, and then one count he did go to a bench trial on, and was significantly found guilty of that as well. I'm going to be focusing on assignment of error 3 about the flight instruction, because I believe that there was not enough to show that Mr. Ammons took affirmative steps to evade the detection and apprehension of the police, which is what this court and numerous other courts have held is the standard for a flight jury instruction. Again, like I stated, there were 4 minutes between the time of the shot being heard by the neighbor and her calling the police. The police or the neighbor actually testified at the trial that she yelled out to Mr. Ammons that she was calling her mom, who I think she was living with at the time, and also calling the police. She also testified he didn't have a phone on him, so it made sense that she was the one to call the police and get them there. during that time, he was still there. He stayed there. Like I said, there was testimony that about 4 minutes had elapsed since from the call to when the police arrived. And Mr. Ammons was just he was there. He wasn't leaving. He didn't leave as soon as the police pulled up. He stayed. He was trying to, I think in a state of shock and trying to, he was just kind of walking around and again, hysterical. There was testimony that, obviously he wasn't the one to attend to her wounds. It was a neighbor that came out and from across the street and helped. But this doesn't mean that, he didn't care, that he wasn't trying to, flee. It wasn't that he was trying to evade it. I think he was just in a state of shock. He was just, his significant other had just been shot. And from what it looked like, it was very critical. They say that she got shot in the neck, and that blood was, spurting out of her neck as her heart was beating. With each heartbeat, you could kind of see it coming out. So anybody looking at her probably thought that she might have died. And so the jury was given this flight instruction that, they may consider the evidence and see it as, a guilty conscience if they think that there was enough. I know that, obviously this is generally found to be a harmless error. However, I would argue that it prejudiced Mr. Ammons because the jury instruction, had they not been maybe pointed this evidence out by the judge, not knowing exactly what a flight instruction is, then they might not have thought that, he was trying to flee. They might not have thought that, it went to any guilty conscience on his end. And so I think by the instruction being given, he was prejudiced, and it definitely played a part in him getting found guilty. And but for that not getting this jury instruction being given, he might not have been found guilty at the trial.
Counsel, I just have a couple questions. One is in regard to the facts. I know you said that he wasn't attending to his girlfriend, and the neighbor came out, and the neighbor also said, I'm calling the police or whatever. But did anybody hear him crying out for help? To get help or to call 911 or anything like that?
People were saying they didn't, I don't believe there was testimony as to what he was screaming out for, but he was screaming, and they said that he was frantic and hysterical, and he was screaming out. I don't know if they actually testified at the trial as to what he was screaming about, just that he was screaming.
And I understand, obviously, that a flight instruction was given, but the jury would have heard regardless that he left the scene of the crime, that he left after the officers had told him to stay.
Correct. And I think the problem with it is that, he stayed for a significant amount of time. And even so, when he, like I said, when he was leaving to get in the SUV, there was testimony that at that time, the victim was being taken by ambulance. So, I think an argument could have been made, or could be still made, that, he was just going to meet her at the hospital, or he was just going, at that point, she was already being attended to. I think, like I said, that there's a standard that he has to take affirmative steps to avoid detection and of apprehension. And when the police were still there, like I said, when they, acknowledged him, they said, hey, stay here, and introduced themselves. I think he sat down, and he did stay on the neighbor's porch for a little bit. And at that point, no officers stayed with him. They went back to attending to the victim, which is completely understandable, but it's not like an officer stayed with him and he was trying to, leave at that point. When an officer stayed with him, there's been case law that, when an officer isn't staying with them, or, an officer already makes contact with them, and then they're still, there and not trying to resist or not trying to run away, or do anything right then and there, then, I don't think a jury instruction or a flight instruction for the jury is warranted. They would still obviously hear that, he did get into the SUV, but I think the problem with that is that, despite that, I think the jury instruction further points out to the jurors that, that they should, take all that into consideration more significantly than maybe they would have had they not heard that jury instruction. So all that's to say that I think he was prejudiced by this jury instruction, and that it was the trial court's abuse of discretion in finding him or giving this jury instruction, and then consequently he was found guilty of all the counts after that instruction was given and after all the evidence was heard. Thank you.
Thank you. Mr. Murphy?
Morning, Judge Carr. Morning, Judge Teodosio and Judge Sutton. Judge, with regard to the third assignment of error the opposing counsel has chosen to focus on, I think the most critical fact that that's been presented to this court erroneously is that Mr. Ammons stayed on the porch for some length of time. The video is timed. There's times on there. He stayed on the porch about 15 seconds. That's it. That car that he left in had arrived on scene, was sitting there as soon as this police officer, well, first of all, let's be clear. The police directed not only him to stay, but anybody else who was, kind of in the neighborhood there on the street. And everyone else did. He did not. There was no testimony, Judge Carr, at least to my recollection, about what Mr. Ammons was yelling. But I think that then lends itself to answer your question, Judge Carr, that no, I don't recall, from my own recollection, any indication in the record that Mr. Ammons was yelling, somebody call 911. His actions pretty clearly demonstrated that he was concerned for himself only and not for his significant other laying on the ground who'd been shot in the neck. This case lines up almost directly with regard to the flight instruction, I should say. I mean, it lines up almost directly with this court's decision in Johnson within the past year or so. The 2020 opinion in Johnson that the state cited in its brief, in which an officer walked up to a car at the location of a reported shooting and was able to identify Mr. Johnson as one of the occupants in the car, told the occupants of the car to stay on scene there, and the occupants left the scene, the car driving away. And this court said in that case, a flight instruction was provided to the jury, the trial court did, and this court ruled that that was not an abuse of discretion on the trial court's part.
Was there further evasive action in Johnson? I'm trying to remember, because in this case, the car stopped immediately 100 feet from the scene, and it seems like Mr. Ammons complied with instructions.
Judge, let's actually, Mr. Ammons did not stop. The police pursued him with lights and sirens going. Mr. Ammons was not driving the car.
Right, he was a passenger.
He's a passenger in the car. So just to describe Mr. Ammons as stopping, the state suggests is not accurate. He really had no choice to stop. Mr. Ammons' choice, the choice that we need to look at, is his choice to leave the porch after 15 seconds. That's the choice.
Well, you would agree that he did, once the vehicle was stopped, he did not try to evade any further. He didn't run. He didn't take any other evasive action.
Correct.
Okay.
Which would have given rise to another flight instruction. So the flight instruction goes back to his actions, not after the car stopped. It goes back to the point in time in which he left the porch after he was directed not to. He was in the witness who resides in that house between the location where Mr. Ammons lives and the location where the shooting occurred, which oddly is a 29. Just so the record's clear too, and the court's clear, 2917 is the middle house between 2903 and 2915. It's sort of a bizarre arrangement of addresses, but I just want to make sure the court's clear on that. So there's a resident at 2917 Apple who testified that police told everyone to stay there, and Mr. Ammons is the only one that leaves. Based on Johnson, there was absolutely no abuse of discretion on the trial court's part here. The one other, I apologize, my office phone is ringing if you can hear that. The one other aspect is with regard to the fourth assignment of error, that somehow there was an error in a right to confront SW, the victim, or a confrontation clause violation. And SW never testified. So with regard to any confrontation clause, and I guess I should backtrack one, that it's almost a two-prong argument that Mr. Ammons makes. And the first is actually based on the trial court overruling Mr. Ammons' objection to some testimony from the detective who was testifying about SW being charged and then preliminarily charged by a grand jury, and then charges being dismissed against SW. And there was an indication that that somehow violated evidence rule 611, specifically, or I'm sorry, that it violated, I jumped ahead, that it violated evidence rule 608 as extrinsic evidence, trying to undermine the credibility of SW, but SW never testified. There was no credibility to undermine there. The and it also didn't. Evidence rule 608 also contemplates trying to using a witness's conduct, and again, there was nothing testified to about SW's conduct. It was simply the detective testifying to steps he took in investigating the incident and as a result of his investigation. Based off that same objection that was overruled by the trial court, it seems that Mr. Ammons also brings the Sixth Amendment right confrontation clause argument, and also a right to cross-examine under evidence rule 611. And the Sixth Amendment right to confrontation just simply doesn't apply. I mean, SW is not testifying. It's not her statement. She didn't testify to anything. And then that right to cross-examine just wasn't constrained at all. You can't cross-examine a witness or a person who's not a witness. And then finally, there's also this part where later during cross-examination of the detective, at which the trial court sustained a state's objection regarding what SW told the detective while SW was hospitalized and kind of during an interview. And again, there's a confrontation clause argument brought from Mr. Ammons, which frankly just doesn't make a whole lot of sense, in that that's exactly what the trial court would have been kind of contemplating, it seems to me. That's what the confrontation clause would have contemplated, was this witness's statement can't come in. It's either the witness SW testifies, or the detective can't testify to this statement, because the only reason for Mr. Ammons to try and elicit that testimony would be to prove, to provide some sort of evidence that he did not shoot SW. So he's trying to prove the truth of that statement through not the witness who should be saying it, but the detective. And then there's also this cross-examination, again, under evidence rule 611, it seems it's being offered. But really that argument, what Mr. Ammons is sort of asserting, is that he gets to cross-examine on anything, whatever he wants. And that violated his right to cross-examine, because he couldn't ask the detective what SW told him. And evidence rule 611, though, does contemplate that the trial court has to constrain parts of testimony. The trial court obviously has that authority, and the trial court can't allow cross-examination on something that the rules otherwise prohibit, which is hearsay. Without any other questions from the panel, the state just asks that the judgments and the conviction be affirmed.
Thank you. You have 5 minutes for rebuttal yet.
So just to address a few things. So I know there was some testimony, according to the neighbor, he stayed on the porch, Mr. Ammons, for, a few minutes. Then the video shows, I guess it was only 15 seconds, but regardless, he makes the movement to get out of the car. He was getting into it. And then officers say, please step out and remain here on the scene. And he does that. He doesn't try and run at that point. He doesn't jump into the SUV and, say leave or anything like that. And again, as, Your Honor pointed out, he is, about 100 feet from where the shooting had occurred when they're stopped in the SUV, and he completely complies when they order him out of the vehicle. He is placed into handcuffs without any, incident. He doesn't try and escape. He doesn't stay in the vehicle for any amount of time. He again gets out immediately and complies with officers' orders. Further, I think that this is different from Johnson for those reasons, because he wasn't trying to take any further action to evade them. And, he wasn't trying to run. He was there. Again, it took the police 4 minutes to get to the scene, and he was still there knowing that police were being called and on their way. Initially, when the neighbor testified that she came out of the house after she heard a gunshot and screams, she saw that Mr. Ammons was near her and screaming. And again, there was no testimony as to what she was screaming, but he was right next to her screaming out. So, I think that goes to also that he was trying to scream out for some sort of help. And again, the neighbor testified there was no phone on him to her knowledge. He didn't, have the ability to call the police. As for the confrontation clause issue, I think the problem is that the trial court allowed this testimony in, that the victim was charged, that she was charged with, making false statements, and obstructing. But then they let that in, but then there was a line of questioning that on cross, the attorney asks the detective, if she indicates who had shot her, and he says yes. And then he asked, was it Mr. Ammons, who she said, shot her? And he says no, and then, state objected, and that line of questioning was, left out. And so I think they just kind of opened the door as to that testimony, because they said, what she was charged with, and that I think the defense was trying to say, well, if they can, bring that in, that she was charged, we would at least like to know what, led to those charges. And that's where the line of questioning came from. But unfortunately, that was, not able to be brought in because of the objection being sustained by the trial court. It is, it's correct that, obviously the victim was not a witness on either side. The state didn't call her as a hostile witness or any sort of witness, and defense did not call her either. But
counsel, I'm sorry, you need to wrap up. You're out of time.
Okay. So I just think that should have been allowed in over objection. Thank you, Your Honors.
Thank you. Thank you both for your presentations to the court this morning, for your arguments, and we will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as we release on the Supreme Court website, and you can access through our website as well.